let me welcome our next and last panel for today to the stand. The Quattrone Center has had a special interest in conviction integrity units really since our start, and the role that they can play in righting wrongful convictions. And so it's with great pleasure that I welcome my colleague Marissa Bluestine to the stand. Marissa had a big role while she was at the Pennsylvania Innocence Project in helping to reboot the Philadelphia Conviction Integrity Unit. And she's assembled an all-star cast of conviction integrity leaders from around the country to talk to us about this important issue. So thank you all for being here. And Marissa, I will let you take it away from here.
Thanks, John. Thank you. Second here.
Thank you.
Thank you. We know who we are, and then we know who we are, and then
Oh,
Oh, look at that.
good afternoon, everyone. As John said, my name is Marissa Bluestine. I am one of 2 assistant directors at the Quattrone Center, and I clearly missed the meeting when we discussed what time our panels would go, because I got the 4:30 p.m. slot. So, but I couldn't be more happy than to be joined by the women to my right. Nikki reminded us this morning about the role of the prosecutor is in the process of being reimagined, and that it also is often requires prosecutors to go against the status quo. I was taking very diligent notes as you were speaking, and I think no function really shows that more than the conviction integrity units. So for those who don't know, a conviction integrity unit is a specialized unit within a prosecutor's office that is charged with looking at past convictions generally to ensure that they have, in fact, integrity, whether because the person is actually innocent or that there was a wrongful conviction for some other reason where the case needs to be corrected. The panel title in your agenda is somewhat it's somewhat of a misdirection. Instead of talking about resistance, I think that's kind of what we initially started talking about, which is somewhat of a theme today. We've heard about judges or defense lawyers or even internally resisting the efforts of progressive prosecutors. Rather, what we're really going to be talking about here is how CIUs have been driving the prosecutor's role to achieve justice into a new quadrant, which is post-conviction, with prosecutors around the country stepping in to investigate wrongful conviction claims directly, often in collaboration with traditional adversaries from the defense bar. Expectations of the prosecutor's role is changing. And from a cultural change within a prosecutor's office to educating the judiciary, CIUs in particular are not just investigating cases, they're actually working to prevent these injustices from occurring in the first place. So we have today a just magnificent panel who they really need no introduction, I think, but they each are going to be kind of addressing a different element or way of looking at that question of integration, as Terri will talk about. So Lauren Lipscomb heads the Conviction Integrity Unit in Baltimore City. She's going to be kind of giving us a historical overview of the prosecutor's role and how it has changed, and in particular with CIUs in terms of pushing the boundaries of what is the prosecutor's role. Next, Terri Rosenblatt from the Manhattan District Attorney's Office, from the Post-Conviction Justice Unit, will kind of be taking that into the internal integration of how to, what happens when we form these units, how do we integrate the unit into the office's structure, and how do we kind of work to look at cases that have been reviewed before, how does that get handled internally. Ginger, who is formerly with the Conviction Integrity Unit of the 9th Judicial District, which is in Orlando, Florida, will be talking with us about cases where she's had to handle other viewpoints from other law enforcement agencies in terms of cases that she's had to deal with and how she's been able to do that. And then, of course, Val Newman, who is the head of the Conviction Integrity Unit from Wayne County, which is Detroit, Michigan. I honestly have no idea what she's going to talk about, but we'll figure it out as we go. But we wanted to kind of get a little bit of information about the folks who are here in the room. So if you haven't done a poll everywhere before, you can blame Paul Heaton for this, who introduced me to this tool. But if you have a phone or if you're online, and this, of course, goes for people who are watching the live stream as well, what's your background? So if you can text MBB to the number 22333 from your phone, or go to polev.com/MBB. You should be allowed into the room, and we can get a sense for our panelists who we have here. Just give that a couple moments to populate in. Yes, sorry, Jeff, it's right there. polev.com/MBB online, or on your phone, text MBB to 22333. Mike Schmidt is clearly not part. Oh, there you go. Okay. Does that help, folks? Give a sense? Okay, great. And the second question that we thought would be helpful for us to know is just whether the jurisdiction, however you define that, has a CIU. And that might be in development, or you may have no clue about whether it does. Any answer is fine. There you go. So. Okay. So if you don't have an idea, you can talk to us afterward, and we can probably let you know. All right. So I'm going to turn over to Lauren. For the first, you can just hit that. That'll move. It's all on one master.
Great. Hi, everybody. Happy late afternoon. My name is Lauren Lipscomb. I am the chief of the Conviction Integrity Unit in the Baltimore City State's Attorney's Office, similar to Doyle, who works in a sister jurisdiction in the great state of Maryland. I am a career prosecutor. I walked through the door of the Baltimore City State's Attorney's Office in 2003 as a law clerk, finishing up law school and about to take the bar. I passed the bar, and I've been a prosecutor ever since. And most recently, the chief of the Conviction Integrity Unit. And in this role, I developed the Conviction Integrity Program, which is a subunit within the Conviction Integrity Unit that I run. I'll give you a little bit more information about that moving forward. Who here has heard of retained surgical items? There's 1, 2, 3. Michelle, you have? So I had never heard of retained surgical items before preparing for this presentation. I was just wondering, what is it called when they leave something, when they leave something inside of you when surgery is committed? Apparently, this is the name of it. So I think some of us have probably, or all of us maybe in the room at least, have seen these types of photos where surgical instruments have been left inside patients. There's the photo credit. I also read an interesting article, which is apropos to what we're going to be talking about today, or at least what I'm going to be talking about in my part today. So this article is When Your Surgeon Accidentally Leaves Something Inside You. It was in the Washington Post in 2014. The problem is, while rare, retained surgical items can cause quite a bit of harm beyond pain and suffering, numerous injuries, as well as, of course, death. The costs are not surprisingly very high, approximately $63,631 per hospital stay to remedy to bring someone in and to remove a retained surgical item. Awareness is something that the medical community has been working on, apparently, for years and years and years, decades and decades, to make sure that they build awareness about the perils of retained surgical items and in their efforts to try to prevent them. And prevention in particular, X-rays and barcodes have helped detect lost material. And radio frequency detection systems were introduced somewhere around 2014, and at that time were the best and most cost-effective way to keep track of those sponges. Why am I mentioning this? The reason I'm mentioning this is because convicting an innocent individual represents a failure of our criminal justice system, just as a retained surgical item represents a failure of the healthcare system. And you'll have to excuse me, I am a trial attorney. by trade, practice, and experience. So analogies are my thing. I'm always, when you're talking to juries, you're always looking for the analogies that'll resonate with the jury. So you're going to have to bear with me. We're going to keep on with this analogy throughout the presentation. According to the experts, the frequency of retained surgical items occurs on average twice per year per hospital, which translates into a rare occurrence. When a retained surgical item is discovered, the standard remedial action is not to ignore the item and hope for the best. It is to remove the item. While the instances of erroneous conviction are infrequent, any occurrence represents an injustice. When it is discovered that an individual has been convicted of a crime not committed, we as prosecutors have a responsibility to take action, not hope for the best. Across all jurisdictions, our collective understanding of the professional and ethical role of prosecutors as ministers of justice has evolved over decades to become more clearly defined at all stages of contact with the criminal justice system. The evolution of the present-day American Bar Association model rules of professional responsibility has occurred since 1908. In 1908, we were guided by the canons of professional ethics. Namely, prosecutors that were charged with, or at the aspirational charge was to be the primary duty, that the primary of the duty of a lawyer engaged in public prosecution is not to convict, but is to see that justice is done. Following that, what developed was in 1969, the Model Code of Professional Responsibility. The responsibility of a public prosecutor differs from that of the usual advocate. His duty, and you can tell the year, his duty is to seek justice, not merely to convict. Present day, the Model Rules of Professional Conduct Standard 3-1.2 functions and duties of the prosecutor. The prosecutor should seek to protect the innocent and convict the guilty, consider the interests of the victims and witnesses, and respect to the constitutional and legal rights of all persons, including suspects and defendants. The prosecutor is not merely a case processor, but also a problem solver, responsible for considering broad goals of the criminal justice system. When inadequacies or injustices in the substantive or procedural law come to the prosecutor's attention, the prosecutor should stimulate and support efforts for remedial action. What does this prosecution role look like in practice within agencies? The development of a specialized unit such as a conviction integrity unit with established protocols and procedures when raised in or out of court is one way that this can manifest in a prosecution office by way of developing a formal unit. Or in the alternative, especially for some of our smaller jurisdictions, perhaps development of formalized protocols or a system designed to structure how claims of factual innocence are processed when raised in or out of court. In our office, the Baltimore City State's Attorney's Office, we have the Conviction Integrity Unit. Within the Conviction Integrity Unit, we've got the Conviction Integrity Program. Our Conviction Integrity Program's purpose, generally speaking, is to review claims of factual innocence. The structure of our program is that we have 3 full-time staff members that are devoted mostly to investigating those claims of factual innocence. We have an incoming caseload of approximately 150 cases per year in terms of cases that we lay eyes on and review to some extent. The process within our Conviction Integrity Program to review incoming cases are that first we look, as to extrajudicial claims specifically, we screen the cases to determine whether or not we've got jurisdiction and whether or not there's a claim of factual innocence that's actually been raised. For a long time in the state of Maryland, the Baltimore City had the only formal Conviction Integrity Program, which meant that we got applications from all over the state of Maryland. And at times, we got applications from Florida. We got applications from Texas. And so during that first leg of when we were really first getting up to speed and ramping up and getting formalized, screening was actually something that was pretty significant. And to the best of our ability, we would package up those applications and send them off to the jurisdiction where they are more appropriately housed. Again, because the role of a prosecutor is to review those cases. If somebody has been wrongfully convicted, if somebody is factually innocent, well, then we aren't going to throw that claim in the garbage because it's not our jurisdiction. We feel as though we had an obligation to go ahead and send that material to wherever the home jurisdiction is. After screening, those cases that survive the screening process, they move into initial review. Initial review is really a document gathering and document review stage of review of these cases. We're reviewing anything that can help answer the question of whether there is a meritorious claim of factual innocence. That could be pulling back the court file, the state's attorney's office file, the Baltimore Police Department file, the appellate file, anything that gives us that puts us on the right path to determining whether or not there's a meritorious claim of factual innocence. Those cases surviving initial review may move into the investigation phase. The investigation phase is an all-encompassing, no stone left unturned review and investigation into the merits of the claim as well as into the facts and evidence that was known prior to trial, during trial, and after trial. It is a full-blown, full-scale investigation. We interview witnesses, we go to the crime scene, we analyze where the vantage point is of eyewitnesses. We do everything that you could possibly think of to try to ascertain whether or not there is a meritorious claim of factual innocence. Those cases, and as you can imagine, of those 150 to 200 cases, the pool is starting to die down quite a bit by the time you get to the reinvestigation phase. After the investigation phase, if it appears as though there's a colorable meritorious claim of factual innocence, then the case is put together. I'll put together what is an internal report, and I will send that report up to the front office for our state's attorney to take a look at and review, as well as other front office executive team leadership to review to determine whether or not our office is going to agree to relief. We also handle writ of actual innocence petitions. So one of the things that I figured out kind of early on, and this wasn't me being so great, this was me looking to others in the nation who came before me to see how they did it. So I will invoke the name of Mark Hale in Brooklyn, who I asked numerous times, please give me some insight as to the program that you developed here in Brooklyn and how you developed it and what are the kinds of things that you're looking for. And what are an idea of sort of best practices? We don't like to use that term, but best practices or how do you process these claims? And one of the things that was pretty evident and kind of easy to do was that the conviction integrity program needed to review all petitions for writ of actual innocence, meaning that they don't go back to the trial prosecutor. They come to the conviction integrity program so that there's a neutral set of eyes reviewing the claim.
So in Maryland, there's a separate procedure for actual innocence claims that doesn't exist in any other state.
Thank you. I just learned something new. So this is, in fact, something that is, I guess, different. I think it would be maybe a habeas corpus. Yeah, habeas corpus claim elsewhere. So we handle writ of actual innocence petitions in the conviction integrity program. As well, we get internal referrals from prosecutors in our office. If they have a post-conviction or other post-trial matter where someone is claiming factual innocence, they'll kick it over to the conviction integrity program to go ahead and take a look. So we get those referrals internal as well. And then lastly, we get numerous external referrals. We get referrals from other agencies. We've gotten referrals from retired homicide detectives. We've gotten referrals, of course, from defense attorneys and innocence organizations. And then we also have had our fair share of referrals from victims' families. And actually one exoneration that was brought to us that was initiated by the victim's family contacting the Innocence Project and then in turn contacting our office. And so we get pull cases from several different sources. Our unit, we're small but very mighty in Baltimore City. We have had 12 exonerations since the inception of the formalized unit that is the Conviction Integrity Unit, program. For prosecutors to step outside the role of case processors and into the role of problem solvers within the criminal justice system, prosecutors must have the trust and confidence of the community served and among criminal justice stakeholders. That is key. I've seen a few presenters today who have also touched in on this concept. That is something that is absolutely critical when doing the work that we do as prosecutors. As prosecutors, when we discover an unjust outcome and ask the court to grant relief, we are asking the judge to make a major change, which is to reverse a jury finding, a major change. That cannot be underestimated enough in terms of the gravity and the import of what a prosecutor is asking a judge to do. So when you're thinking about it from the judge's vantage point, here are a few of the things that a judge is probably considering when we walk into a courtroom and say, hey, judge, you know what? We think we made a mistake. Could you grant this writ of actual innocence so that we can let this person who we believe was wrongfully convicted go free? From the standpoint of a judge, if we can all imagine, the judge might be thinking that granting relief represents a change from the typical prosecution role of from the typical prosecution post-trial position of defending a conviction. That's the typical view of prosecutors post-trial, is that we walk into a courtroom and we're automatically going to be there to defend a conviction. So we're representing a different position that we have when we walk in and say, hey, can you please grant relief here? Also, the judge is being asked to rely on a proffer of facts, evidence, and relevant law from attorneys often without an evidentiary hearing. So imagine that, what the judge is being put in the position to do. We want you to reverse a jury finding. Oh, and by the way, we're not going to have an evidentiary hearing today. We're just going to ask you to take our proffer as to why we are asking you to make this, monumentous change in terms of reversing a jury finding. As well, there's no visibly quantifiable evidence that an error occurred, i.e., we don't have an X-ray of scissors in the patient, back to that analogy. So there's nothing visibly quantifiable that the judge can say, oh, yes, of course, there's an error that's occurred there. Also, the judge is often new to the case. The trial likely occurred years earlier and before a different judge. The odds of the judge that you were before being the same judge that was familiar with the facts from having called balls and strikes and presiding over the trial are slim to none. It has never occurred in Baltimore City. Most of the judges of the cases that we review have either moved on, retired, some unfortunately have passed away, but the odds are that the judge that's assigned to review these claims is not the trial judge, so they're completely new to the case. As well, post-trial law is an entangled complexity. We were talking about that a little earlier during one of the breaks, which may not be familiar territory to the judges, versus Fourth Amendment law, for example, which is invoked daily in criminal court. Every single day, motion to suppress photo array, Fifth Amendment motion, whether or not Crawford has been violated. These are normal criminal laws that are invoked on a regular basis every single day in criminal court in most trials. And so that becomes the bread and butter of what the judges are most familiar with, and frankly, what most of my colleagues are familiar with. So this kind of weird, wonky area of post-trial law becomes something that's a little bit of a stretch out of familiar territory. As well, of course, and I'd like to remind some folks of this, and the judge was not present when the offense occurred. So I have no clue of what transpired that day. And so we're asking a lot of the judges. So it is very important that we make sure that we're building trust and confidence so that so that when we go in and we proffer that this is an action that we need to take this action and that the judge needs to reverse this jury finding, we need to make sure that we have established a record of trust and confidence. How do we do that? We demonstrate due diligence, credibility, and professional responsibility by instilling trust and confidence in any prosecutorial action. Due diligence looks like leaving no stone unturned. Again, this is from the prosecutor's vantage point to prosecutors in the room. Leave no stone unturned. Provide demonstrative evidence that reflects you have undertaken a thorough investigation in which pieces of evidence have been properly corroborated, accurately and precisely identifying key facts and evidence presented to the jury, along with the result of your post-trial investigation, will support that you have done adequate due diligence for what you're asking the court to do. Credibility. Be candid, be candid, be candid. Stay on the facts and the evidence. Skip the editorialization. There is no use for editorialization when presenting to the court the evidence and the facts in support of the position from the state's vantage point on why you want the court to reverse a jury verdict. Inform the court of all relevant inculpating as well as exculpating material so that the judge is as up to speed as you are in the case so that they can make a better and informed decision. Thank you. Professional responsibility. I'm going to start speeding up here. Highlight the prosecutorial role to ensure just outcomes, demonstrate compliance with all relevant laws. Res ipsa loquitur. That's a nice law school term. Demonstrative evidence of having done due diligence, being thorough and candid will speak for itself in drawing a picture as poignant as an X-ray reflecting a pair of scissors inside a patient. And lastly, building awareness, conviction integrity within a prosecuting agency, formalizing the ABA model rules relating to the special duties of a prosecutor within prosecuting agencies, that builds awareness. As well, symposiums such as this one delivers messaging and builds awareness of the importance of conviction integrity work. Targeting agency or bar association training modules to broaden awareness of conviction integrity work and its relationship to the role of a prosecutor is key as well. And then lastly, similar to homicide units, sex offense units, standardizing conviction integrity within prosecuting agencies by devoting full-time staff normalizes the work. So I would just leave you with, here's my contact information. And just like we don't consider, oh, is it high time that we evaluate whether or not we're going to prosecute sex offenses? Well, a prosecuting function such as making sure that we are not standing by if a person has been wrongfully convicted, that is something that should be just a normal role of a prosecuting agency. Thank you.
Hi, I'm Terri Rosenblatt, and I'm the chief of the Post-Conviction Justice Unit at the New York County DA's office, which we also call Danny. I am thankfully going to have not very much to say because Lauren really said it all. I mean, thank you. And I think that really hit all the points, and I will take the liberty of speaking for all of us and saying I think we really all share in your values and in your work, and thank you for coming first. So what I want to talk about is one of the wonderful points that Lauren made, which is how do you integrate an independent conviction integrity or post-conviction justice unit into a prosecutor's office, and what are some things that a prosecuting office can do to normalize the work and make it part of the standard function of a just culture that we all embrace as prosecutors. I'll start with a disclaimer. These are my opinions. They're not anything official. They don't represent any official position of the New York County DA's office or any of its employees. So the Post-Conviction Justice Unit in the New York County DA's office started in 2022. It is a team of amazing people. Most of them are sitting over here. I'm just going to look at them because I'm nervous. But we're 7 attorneys, 3 investigative analysts, and we have a dedicated investigator. We were created by District Attorney Alvin Bragg, and our mission is to review closed cases. We have a different name than traditional conviction integrity units, and we have that name to embrace the fact that convictions are not always rightful or wrongful. Instead, there are multiple measures of justice that may be appropriate after a sentence is imposed, which I think has been another one of the themes of today. Our mission at PCJU has 3 main pillars: independent and impartial post-conviction reinvestigation done in collaboration with impacted individuals and their counsel to determine whether a conviction should be vacated or modified where there is no longer confidence in the outcome. Our second pillar is having services and support to exonerees, but also in critically, victims and survivors who may be deprived of closure. And promoting conviction integrity in future prosecutions by advising our office in best practices, including through new trainings and root cause analysis and reports. So that's sort of post-conviction justice at Danny. I want to talk about post-conviction justice and Danny and what it's been like to integrate an independent post-conviction justice unit into a DA's office. So when we came in, our office had a long history of doing really important and meaningful and profound post-conviction work. We weren't an office that never did it. We had a conviction integrity program. What happened that's different is we came in as a fully independent unit and a fully staffed unit. And so we had a sort of interesting set of opportunities and also challenges of being the continuation, but also taking things in a different direction. And I think it bears mention that, I came from a civil rights and defense appellate background, and I was not coming in as someone who had been a prosecutor. And so it was really important to think about how, given all of that, how do we integrate into the structure of any DA's office, particularly our DA's office? And I can't emphasize enough how important thinking about that and being intentional in it has been and will continue to be. And there are some reasons for it. And one reason that you need to be integrated into the office is you need the institutional knowledge of your office. People often stay in prosecutors' offices for a long time, and our office is no different. We have folks who have been in our office for 20, 30, 50 years. And the institutional resources, the knowledge of how things were done, of even particular cases is invaluable. And to do post-conviction justice, right, we need to be able to access that. There's also the sort of hard resources, right? We are a law enforcement agency that does an incredible job of protecting public safety in New York, and we have tools to do that. Those same tools can be used really powerfully in post-conviction work. And so we need to be able to integrate the same tools that are used in investigating and prosecuting live cases to investigating potential claims of unjust conviction or innocence. It's also critical to promote a just culture. Post-conviction justice units or conviction integrity units often lead on issues like rethinking confessions, rethinking what it means, identification evidence, rethinking some of the values that were brought to bear in older cases versus newer cases. And so that just culture can't be siloed within a conviction integrity or post-conviction justice unit. It has to be integrated. And then there's the really intangible thing of you have to like going to work every day, right? Like you work in an office, reinvestigating closed cases can often take years. And you have to be able to like see somebody at the water cooler, join the softball team, go out for happy hour. Those things, like they seem silly, but they're really not, because we want the folks who are doing this work in DA's offices to stay and be motivated and be happy staying. So none of those things undermine independence, right? We talk about how critical independence is, and it really is. We are independent. We don't report within the trial or appeals division. We report directly to the executive. And so all of those important factors for integration don't undermine independence as long as we are clear in our mission and our structure. And so boundaries are set early on and clearly communicated. So I would love to have lunch with my colleagues in the trial division, but just like they're probably not going to tell me about the big gang takedown that they're about to do, I'm not going to tell them about the old case that I'm reinvestigating and thinking about potentially recommending relief on. And those are fair and normal boundaries, and we just have to normalize that and talk about it and be okay with it. And part of that also is normalizing, as Lauren said, normalizing post-conviction work as part of a regular part of a prosecutor's office. At the exact same point, in our office, we have a sex crimes division. We have a hate crimes unit. We have construction fraud. We have lots of different pieces of the prosecutorial space that are occupied. Conviction review is just another piece of the prosecutorial space, and that's what we happen to occupy. And that helps, especially if our elected DAs and executives support our work. And I think, we've been so fortunate to be in a time when there is incredible support from electeds and executives. And I think you really need that to maintain independence. And so that's sort of why is it important? What does the office need to do? And then what do we need to do as folks who are working in this space to make sure that we are giving as much as we're getting, that we're sharing our resources, and that we are doing everything we can to be good partners and also to integrate ourselves. And one of those things that is critical, and it's just critical for all prosecution work, it's critical for all defense work, for post-conviction work, is empathy, right? We can't, that is at the heart of what we do. So it's important for the folks who are doing this work to both say, we are normal, we are here, we're going to stay here, but also we understand that the process of getting us here is one that might feel different for folks who it's new to. And that's okay. We can empathize with that. And by empathizing with it, we can sort of meet people where they're at and communicate why what we're doing is so important. Empowerment, right? Again, support from executives and electeds, being empowered to come and say these things out loud and talk about them and name them is incredibly important for a unit like ours to succeed. And then the last thing, and I'll just go a little bit more into this before I stop, is sort of educational tools and data for bringing longtime staff up to speed on wrongful convictions. Because, everything Lauren said, I'm saying, but another thing that I want to emphasize is those of us who are doing this work are not simply stepping into this role as like a reassignment, right? We weren't sort of working arraignments and now we're going into post-conviction justice. We are experts in a field where expertise is required. And I think that is something that not everyone completely understands. Because it's not something that's talked about very much. You can be an expert litigator, you can be an expert trial attorney, you can be an expert defense attorney, and you can also be an expert in running, operating, investigating post-conviction cases from a prosecutorial lens. And that is something that we have and that we need to communicate that we have and share. And so there's some really important tools, I think, that help with that. One and another sort of theme of this conference is data. Data is power, I think, always. And one piece of data that is really critical that shows why we are so important is that judicial review doesn't get the job done when you're talking about innocence cases, right? There are some great studies on, great is the wrong word, horrifying studies on this. In 2011 in particular, Brandon Garrett did a study showing that of 250 DNA exonerations, more than 90% failed judicial review. And similarly, in 260 defendants exonerated after a conviction for committing violent felonies, there were people who could not get review unless there was action by prosecutors or pardoning authorities. So it's when we the great thing about the DNA exonerations is that it gives us a baseline of ground truth. But of course, innocent people are not only people who have DNA in their cases. And people who are innocent, but whose cases have evaded judicial review because of EDPA, because of procedural bars, because it is very hard to overcome the sort of psychological biases that prevent conviction review. Those all are critical, and it's why you need people who have expertise sitting in the seats of power looking at these cases. Humanizing, right? Humanizing the work that we do, talking about individual people who have been wrongfully convicted and how those cases unwound and what we learned. I mean, this is just a half dozen of, as we know, thousands, but really talking about it in terms of the human beings who are impacted in the stories of their cases, I think is often very enlightening for folks who aren't usually working in the post-conviction space. The National Registry of Exonerations is an amazing tool. If you haven't spent time on that website, please do. This graph, which is a little bit hard, it's a little bit hard to see, but this graph is one that I use a lot when trainings because they update it regularly. And what it is a chart of the main causes of wrongful conviction. So they take the people who have been exonerated, they look at the causes of their wrongful conviction, and then they distill it into visual data. That is great on its own, But the point of this graph that always really gets me, and I think is so important to talk about when you're talking in prosecutorial spaces, is that the sum total of the causes far exceeds the sum total of the exonerations. And what that says is that almost every wrongful conviction has more than one cause. And that speaks quite clearly to the fact that our system is one that is imperfect and that requires expertise to understand why a conviction could be a wrongful conviction or could be a conviction of an innocent person. And then the last thing, right, not just because we're here, it's only the last thing because we're here and I wanted to finish with it. If I were somewhere else, it would be the first thing, because it is really the most invaluable resource. It is sort of, it has been what folks have done here at the Quattrone Center, what Marissa has done, has been our guidebook. Most of our internal manuals, the collaboration agreement that we use are fully plagiarized from convictionreview.net. So thank you for that. And really, the thinking about this and having the academic backing and the institutional support of a place like Quattrone Center and Penn has really been invaluable in setting up our unit and thinking about this work. So thank you. And that's.
So of course we still are waiting to hear from Ginger and from Val. So I would just ask folks indulgence for maybe another additional 5 minutes going beyond our 5:30 time. I'm not even looking at John for that, so that we don't, rush through the folks we have. So
we got plenty.
I just don't want you to feel like you
And
have
the
to rush
questions.
through. Ginger?
Well, good afternoon, and thank you for staying with us. Excited to see all of your shining, happy faces out there. Thank you so much. This is such an important topic. My name is Ginger Miranda, and I'm from Orlando, Florida. Yes, I said Florida. Thank you. Thank you for your kindness. I wanted to talk about, or actually, they told me I had to talk about this, but a little bit about some of the things that actually have already been said today, but I wanted to kind of talk to you about the importance of why this is. Our first keynote speaker, Mr. Polite, he said that it's important to get out to the stakeholders. And I think when you're dealing with conviction integrity, that is one thing that as a director of the unit, I try to do as much as possible. When we're talking about trust and legitimacy, we can watch all the YouTube conferences and we can read all the things, but it's the human contact. So my part of it really is to talk to you about building bridges to those community stakeholders and to build relationships within those. So we don't have those cool T-shirts like I know, who was it? It was Lindsay Olson this morning showed us the picture with the cool T-shirts. I'm definitely asking my elected for cool T-shirts now. But that was very important because that emphasizes the fact that we cannot stand as an island without the buy-in from our community stakeholders. And so it's important that as a unit, we're out in the community and we're talking to our community leaders, our judges, our law enforcement, our DNA lab. These are all valuable resources, not only to help us do the work that we do, but also to help them spread the word about the importance of conviction integrity. These are our best methods of getting the word out there because I was a defense attorney for 25 years. Half of that career, I was a public defender. And I can talk until I'm blue in the face about, how important that work is. But now as a prosecutor, I've had to step back and kind of rethink, right? It's a different vantage point or different perspective on what justice looks like. And it's so important that we bring others to our vantage point. Now, I'm an avid photographer. Anyone else here love to dabble in photography? I love photography. And one of the things that I love most about photography is that it gives you a different perspective. And it might be just that we live life so fast that sometimes we don't capture that moment. And sometimes in a picture we do. My daughter, she's a filmmaker, so she likes to do the video thing. But I'm old-fashioned. I still like the pictures. I like to just grasp that moment. And one of the things that brings me to is the fact that there may be, and I'll go to the title here, which I liked, some resistance to the work that we do. And that does happen. But there is no resistance once you educate people, once you teach them why, just like you heard from our presenters here today, why the work that we do is so important. We don't want anyone walking around with a scissor inside of their abdomen, I think it was, any longer than they absolutely have to, right? We want to get that scissor out. And all of us as a society can think about the concept. And once we understand it, right, we can say, yes, this is important. And that way we can then funnel our resources and, help to make sure that every office, all of the offices should have a conviction and integrity unit, because they are that important. And the best way to do that really is, again, think about it as a sense of you're building relationships, because we need to build bridges so that we can bring everyone over to conviction integrity. Right?
Yeah.
What do you think about that, Valerie?
I love it. Thank you. That's her handoff to me. All right, I'm going to be really quick so we can take questions. I just want to echo everything, obviously, that everyone has said, because I agree with it. And I want to build on Ginger's building bridges, because there's definitely challenges to doing this work. You have to deal with police departments that don't want you looking into their cases. You have, you grant relief to somebody, and then there's a civil lawsuit. And then the civil lawsuits engender a lot of negativity among different people. And you have a community that can often feel unincluded, especially when they see people are being wrongfully convicted. And then, I don't know about the rest of these folks. They seem to have more money than we do in Wayne County. But we've been up and running since 2018, and I have people who have been sitting in the queue since 2018, cases we haven't gotten to. And so that's a challenge. There's challenges all over the place, and my heart breaks every single day, every time I have to write a letter to somebody that says, I'm really sorry we haven't gotten to your case yet. People start losing a little bit of faith that you are real and you're really doing the job. So it is important to integrate these units, whether it's a full unit or if it's a small entity. If you can work with a statewide unit, if you can combine resources with other local prosecutors' offices, this is a justice issue. And we have to talk about it as a justice issue. And that normalizes it, and it takes it out of the political sphere. Because if this is a progressive prosecutor issue only, then you're open to the whims of the people we've heard talk about in terms of people being in office and how long they're going to last and whether this is something that's going to stay. It really needs to be mainstreamed and normalized, because a good prosecutor's office, any prosecutor, has to care about justice. And if you have an innocent person or the wrong person, or you're not sure if it's the right person sitting in prison, then you have potentially the real perpetrator, or for sure the real perpetrator, if it's an exoneration case, running around in the community getting a free pass. One of my recent cases last year was a gentleman who was in prison for sexually assaulting 2 minors. There was DNA that had been taken, sent to the lab, yet his defense attorney let him enter a plea without the DNA results coming back. His appellate attorney filed an Anders brief and dismissed his appeal without ever looking into the DNA. By the time we got the case, he'd been in prison for 15 years with DNA results that had come back 2 weeks after his sentencing that cleared him of the crime. Nobody did anything. It's an abomination. I mean, really, it's so sickening to think of things like this. But let's compound that abomination, because the DNA was put in a CODIS and came back to a serial rapist. So this man had been free for 15 years, continuing to sexually assault minors, while an innocent person sat in prison for multiple years with so many signs that he was wrongfully convicted. It's hard to fathom that the system failed at every single level of that case. And when you talk about this work and you think about this work, there's so many ripple effects into the community. It's not just the real perpetrator, but it's people who are being victimized in the community because their loved ones are being taken from them wrongfully. They know it. everyone in the community knows, when a wrongful conviction happens. I had one exoneration case where the victim's sister stood up in court and said to the judge, "You've just convicted an innocent person. This person did not murder my brother." She knew he didn't do it. Nobody would listen. And when we found the police file, there was a little yellow sticky on the folder marked perp, and inside was a picture of the perpetrator. These things you cannot make up. And they're horrifying because everyone knew that this man didn't commit the crime. The victim's sister knew that an injustice had happened. And yet, again, it took 15 years till it came to my unit for us to do the investigation and get this man out of prison and identify the actual perpetrator, who, of course, by then was serving time for, 12 or 14 violent offenses. I don't remember how many violent offenses that he was allowed to perpetrate in the community because nobody arrested him for this crime. So the key here, I think that if we can leave you all with, and if you can tell there's a definite theme among the presenters here, is that this is a justice issue. There are no barriers that cannot be overcome. You have the help of the Quattrone Center. You have John, who wrote the seminal white paper on conviction integrity units. You have assistants. You have all of us who are always willing to talk to any elected who's thinking about starting a conviction integrity unit. And this is a necessity for the public to have trust and faith in the prosecutor's office. I can tell you how many conversations I start off by saying, "I know you probably don't trust me because I'm with the prosecutor's office, but let me try and convince you that you should." To try and build a relationship with people, to get to the truth, to get to the information that we need to get to figure out if justice was served or not. And so I'm going to end there and allow time for questions.
So one issue that I think that has been touched on a bit, and I know, Val, you've dealt with this, and I believe, Lauren, you have too, which is normalizing the work that you do with the victims. They've been, so many times victims go through the criminal legal system believing that, this person is locked away forever. They got the right guy. It's never going to change. You're changing their world when coming out. How have you gone about normalizing what you do with victims or victims advocates? And I know, Val, you've worked with Healing Justice, and I think others may have as well, but kind of directing it at Val and Lauren for that.
Sure. So I do all the victim notifications myself. I think it's very important that the person who knows the case inside and out is able to be there with the victim, to be able to answer absolutely any questions they have about why we did what we did, what we found, why we reached the conclusion that we reached. I take a victim's advocate with me, but quite frankly, I have found that I do a better job of dealing with the victims. Because the victim advocates just kind of sit there unless someone asks for something, right? They're at least the victim advocates are great, and they're used to dealing with different kinds of cases, though, than these. I think you really need specialized assistance in these kinds of cases because it's been decades. The first victim notification I did was our very first exoneree, Richard Phillips, who had served 47 years in prison for a murder he did not commit. Try going back to that family after 47 years and saying the person you've believed killed your loved one didn't. But I spent a lot of time with them. I think I spent 2 or 3 hours at their house, and we really had a good conversation and talked about it. And by the time we were done, they were like, "I'm so glad that you're there." And they felt nothing but empathy for Mr. Phillips. And in that case, of course, it's always easier if you can solve the crime. And we solved the crime in that case. We had identified the perpetrator, and that's kind of not our job, but hopefully it comes along if it comes along in the investigation, right, that's great, because you can really help victims when you can say, this man didn't do it, but this is the person who did, or this is the evidence that supports that this is the person, we're confident this person committed the crime. But I have also worked with a group called Avalon Healing in the Detroit area, who's great with sexual assault victim notification. And I've worked nationally with Healing Justice, and they're phenomenal, especially with sexual assault victim notifications. And also, just a little plug for Healing Justice. They did come in. We brought them into Michigan and they did a series of 3 in-person retreats with our exonerees. And so they also do, they help exonerees to heal, and they're really I can't say enough good words about the work that they do.
Lauren, did you have anything you wanted to add on?
No, I would just echo really what Val said. In the cases that we investigate in the Conviction Integrity Unit, we make sure that we notify the victims with ample time in order to have as many questions answered between that meeting and when we are actually asking the court to take an action. So there's I can't give a specific time when that sweet spot is. However, there is one. And in all of the cases that I have overseen and investigated, which are the 12 exonerations, we have contacted the victim's family, I'd say probably about 4 to 6 weeks prior to any action being taken in court. And we just, we let the victim's family know. And I also am always present. But it's preferable to have an in-person meeting. So that's always the starting point is, would you like to come in so that we can sit down and review the case with you? And about 50-50, a lot of the victims' families have no interest in coming in, but they certainly have an interest in, in talking with us over the phone. Anyway, and then what we, tend to end with is, there's time for you to talk with other family members and just kind of sit in this information and, contact us and we'll answer whatever questions that you have. But we take it very seriously. I personally take it very seriously. One of the worst parts of the job that I do, as far as I'm concerned, is reopening that wound. I feel so strongly for the victims' families and what they're going through, and that here we are again, and we're the last people that they want to see often. Right. And so we take good care.
Right.
And so, hey, Marissa, I just add that I, pre-COVID at least, I went to people's homes. I did not ask people to come to the prosecutor's office. They could if they want. I offered it, but I tried to meet people where they were most comfortable, and almost always they invited me into their home. Mm-hmm. So I did try to go to them instead of inconvenience. Not that it's, there's all different ways to do it, but yeah.
Yes. Yep. And I think, Terri, this applies to cases that you've worked on, or if not anybody, please jump in. But the question is about, Lauren, you talked about the reversing of a jury finding, but of course some of these are guilty pleas and some are negotiated guilty pleas, where there has been an agreement as to the sentence and before the person has entered. And I think, Terri, if I'm not mistaken, you've worked on some of those. How do those differ, in terms of either approaching the court or approaching your fellow prosecutors when dealing with a negotiated plea that you're now seeking to undo?
The biggest challenge that we have in New York is that we have a Court of Appeals decision, which is our highest court, that says that if you have pled guilty, you cannot reverse that guilty plea with an actual innocence claim. And so there is a legal challenge that presents itself in our jurisdiction when we have someone who is innocent but has pleaded guilty, which of course is completely antithetical to what the research shows, which is that innocent people plead guilty for many, many reasons, so many reasons that Judge Rakoff from the Southern District Federal Court wrote a whole book called Why Innocent People Plead Guilty. So, but that hasn't deterred us, because I do think that there are ways in the law to talk about a guilty plea that where an innocent person pleads guilty, there also is an injustice. And that sort of goes back to the idea of, looking at the registry of exonerations, that wrongful convictions have many, many causes. So there are often pathways that you can take with the court, because where an innocent person has pled guilty, there are usually other things that have also gone wrong. And that's been our experience so far. But I think, one thing that we have been very clear about and undeterred in is a conviction, and innocent people get convicted by juries and innocent people get convicted by pleas.
And I acknowledge the next questions from Jeff Deskovich, who's with us here, of course, an exoneree himself, addressing the issue of length of time. From the time that, and I don't anybody's free to kind of jump on this one, but when you've identified a case that you want to take action on, from that point on, obviously, anytime that you take is prolonging somebody's incarceration, how do you balance those kind of issues when trying to move quickly and yet not so quickly that you're going to upset people who will then, throw it back and say, no, I'm not going to go along with this.
Yeah, this is really an intake issue that we've been battling with, really. And I don't think there's a clear answer. What we did is we have an initial intake system, which kind of maps out what issues appear to be present. And we kind of give them all like priorities based on, how glaring of an issue it is or things like that. But we actually instituted what we called a second intake. And the reason we did that was because we found that we weren't narrowing it down enough. And we were really getting bogged down. Now, our office has 4 attorneys, a paralegal, an investigator, full-time assigned. And so in conviction integrity unit terms, that's a pretty big unit. So even so, we had a fingerprint examiner, and it turned out he was falsifying records. So we had about 2,000 cases to review just from that one act. And that kind of really set us back as far as trying to get through all of our applications. So we were able to reach out to the various law schools and colleges in Orlando and throughout the state of Florida to get interns to come in to kind of help us kind of weed through all, of those many, 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 many cases. And like Valerie said, I mean, our unit also started in 2018, and we still have 2018 cases that we're waiting to get to. But unfortunately, time is a resource, and the number of bodies that you have, we could spend months just reading one record, and that's not even, the full record. That may be just a trial record, or it might be just a part of the appellate record. And so the thing that you certainly don't want to do is you certainly don't want to read something that's in that file, and you certainly don't want to not investigate because you don't want to run to the end and then realize that you went out the door and you forgot to put your shoes on, so you certainly want to make sure you're being very thorough and that you're reading every single piece of everything in that file.
Right. And I think there's
a follow-up.
I'm afraid we're going to have to ask you to ask people directly when we're done, but we have, not to point out the irony between the time it takes to overturn every stone, versus the sometimes rush to judgment that may have gone in getting the person convicted in the first place, and how often those are at odds. But John is over my shoulder, so I'm going to have to say thank you, everybody, for being here, and thank you so much for your time.
Thanks for having us.